He specifically told Ms. Draper
oh shit,
that he planned on leaking embarrassing videos of Taylor to the press, starting with the Barstool video.
Today we're back in court in Utah for the hearing of Taylor Frankie Paul versus Dakota Mortensen and Dakota Mortensen versus Taylor Frankie Paul, because both of them are in a hearing for restraining orders, protective orders against the other. We are going to be dealing with, again, a protective order hearing. We don't watch a lot of them on the channel, but if you have not seen a protective order hearing before, both parties are going to be making allegations of domestic violence against the other party. We are going to see a lot of that.
Well, Your Honor, today we have two competing protective orders, one from Mr. Mortensen and one from Ms. Paul. I'll start with handling our protective order first, and then I'll also respond to theirs to hopefully save time and judicial efficiency. Mr. Mortensen filed his protective order. As you know, Your Honor, in the state of Utah, we have a few definitions for how a protective order should enter. We have to have a finding by preponderance of the evidence of either abuse or domestic violence that has been committed. Also, I will cite Patoli versus Marksberry, which is the case that indicates that the fear component is a component, but it's not required. It's an either or, as the court's well aware. In this case, actually, it's, I believe, rather simple, Your Honor. As the guardian ad litem has previously filed, we have an aggravated assault charge and plea of guilty by Ms. Paul against my client. That's domestic violence as specified exactly by the code, as it's one of the underlying sections. Aggravated assault under 765103 is domestic violence.
This is the 2023 incident.
This is the 2023 incident. I did want to show you Exhibit 11, Your Honor. I know you've listened to it, but that's the recording of a phone call that occurred between Ms. Paul and Mr. Mortensen about a day or two after the most recent incident in February.
Is this the one where it was it was represented she was screaming on the phone? Is this?
There was some screaming, yes, but what was really important was the statements that were made by Ms. Paul during that.
Okay.
For example, at the second, just to help the court when you're looking at it, on timestamp number 2, my client asked, well, you know, why did you attack me? And second 8, Ms. Paul responds, I already told them that. And them, if you listen to the context, was CPS at the time, Child Protective Services. I already told them that, yes. Or yeah, was actually the appropriate quote. But here's where I wanted to really get into. And that was later on, about a minute later in the call, he says, well, I've got to tell the truth. And the response was that it will ruin your life, is what she told him. And then at 1 minute and 52 seconds in, you are never working again. And so that's why, Your Honor, I wanted to explain to the court why my client has multiple incidents of this, continues the cycle. And as you can see from the text message and other things we've submitted.
How are those statements pertinent to his request for a protective order?
Because they show, really, it's just a first step to show the court why, as you might be wondering, why has he put up with this? Why has he waited so long to do anything? The answer is he was afraid of the force that would happen against him. He is coerced either through romantic interest or interest involving his son, and with very charismatic tasks and very charismatic personality to come back and rejoin this romantic relationship until it blows up again. He's subjected to abuse by Ms. Paul. He then goes back and kind of says, okay, I'm going to stop it, and then comes forward.
But if I understand your argument, you're saying it wasn't until she threatened to interfere with his work life that's what prompted him to file for protective order?
He filed actually because of the most recent incident when he decided to break the cycle.
All right.
I'm just showing the audio to say why he was afraid to do it sooner. That's
okay. All right.
Mm-hmm.
The court was particularly concerned at the April 7th hearing regarding the May 27th, 2025 pushing video, where my client, it depicts her unsuccessfully, I'd say, pushing him out of her home. Now, as she stated in argument on the 7th, as she's repeated and reiterated in her declaration submitted yesterday, she should not have pushed him. The court is justified in being even more concerned about this by the fact that Dakota was holding their son. She acknowledges that. Leading up to this incident, so as you know, Your Honor, it's a brief video. Clearly, there's something going on before the video that resulted in this. And there's also additional context afterward, once Dakota stopped recording. Leading up to the incident, in the days leading up to the incident, Ever had been very ill. And that's their 2-year-old son. Ever had been very ill, and they were having a
Ever's the
hard time
child.
getting on the same page about how to treat him, how to help him. She feels that leading up to this and during these discussions, he blew her off when she was trying to bring him up to speed. This created a lot of frustration, a lot of tension in the room, so to speak. He came to her house for an exchange right before the video starts. Tempers flared, and she demanded that he leave her home. He did.
By exchange, they mean custody exchange. Taylor asking Dakota to leave seems to be a fundamental point in all of this repeatedly.
Did not. This is a familiar pattern in this case. The video picks up with her yelling at him and demanding that he leave. He doesn't. He decides to tell her no, and he lectures her. She then attempts to push him out of the house again while she's holding Ever.
He
Right
is
before
holding
he
Ever.
stops recording, she loses her footing and he calls her a fucking bitch. At that point, the recording ends, but what transpires is extremely important for the court to consider as well. And this is rebuttal information, but also something that we would believe give ground to something that we believe would constitute grounds for a protective order in Taylor's favor.
Okay, but
She
you're not
falls to the
arguing that
ground.
yet.
Falls to the floor in her home, and Dakota kicks her multiple times, primarily on the leg. The next day, she's still upset about this, and they're tense in their parenting communications, having some challenges here. So she demanded an apology from him. This is in our Exhibit J. You apologize for kicking me while I'm down on the floor. His response is, not in a million years after what you did to me and my son.
Are you saying that's an admission that he kicked her?
Yes. It's a tacit admission. He does not use the words, I, Dakota Mortensen, kicked you, Taylor Paul, multiple times on May 27th, 2025. But this was the day after. She clearly confronts him with this allegation. You kicked me while I was on the floor.
And he doesn't say, I
And
didn't kick
he
you. What are you
passes
talking about?
by. And he just tacitly acknowledges the allegation. As we transition now into the events of February of 2026, I want to draw the court's attention to our Exhibit I. This is the police report. A lot of interest raised by the court, understandably, at the April 7th.
At the April 7th hearing, the court wanted to know what was going on with the incident from February. And now we know that law enforcement is not charging anyone with regard to that incident. He called it the truck tussle. So this is getting to that incident in February.
It says on March 20th, 2026, the city prosecutor provided me, this is the investigator speaking, with an analysis on the case. She advised that neither Taylor or Dakota are credible witnesses, with both their statements being fraught with inconsistencies, such as Dakota's statement to 911 and Taylor saying she had a bloody nose with no evidence of that being true. That Taylor most likely injured Dakota on February 22nd, ripping off his necklace and causing the injuries she sustained. In causing the scratch to his neck in the process. Dakota causing injuries to Taylor on 223 while in the truck, because the injuries she sustained do not fit him pushing her off of him. The injuries are more consistent with him grabbing her head or neck and shoving her head against the dash.
Which is what
and that
she says
both
happens.
parties are misrepresenting their behavior. Also, Dakota had told her that he had not spoken to DCFS, and when she had spoken with DCFS, they confirmed they had spoken to him multiple times. They then conclude that DCFS might be the best way to help these folks.
There's no criminal charges either way.
Now, again, we've switched gears a bit and kind of drifting into my client's request for a protective order. As it relates to Dakota's conduct, my client has seen patterns of abuse and isolation, harassment over the years. And she would like to highlight just a couple of things that kind of speak to his inclinations, speak to what his desires are for her, his possessive nature. We have submitted as our exhibits B and K, a very small glimpse into his obsession over Taylor, his inability to move on and leave her alone. Perhaps the strangest exhibit of the hearing will be our Exhibit C. It's a 3-page sequence of pictures that depict a tattoo that Dakota received on the inside of his lip, his lower lip, of Taylor's initials.
When?
This was done without her knowledge, without her permission, and during an extremely difficult time in their relationship. It was unwelcome. She told him that. As soon as she found out about the tattoo, she told him that, labeled it creepy, and he just doubled down on it and denied that there would be anything objectionable about it. Finally, Your Honor, I do want to, as it relates to his abusive conduct, I do want to touch on something that is a little unusual about this case.
Okay.
There are a few aspects to it that are a bit unusual, but this is one that my client and I find, I think, relevant, and that is
TV.
a very public leak
Yeah.
of the 2023 Barstool incident to media outlets.
I think that's fair.
One specific media outlet, TMZ, on the same day that Dakota filed his amended request.
You're
for a
talking
protective
about
order.
the affidavit from Draper.
Yes.
Okay.
Yes, she touches on that. Yes.
I think it's a fair argument to say, look, if he's saying he wants this to be resolved in the best interest of the child, why is he leaking this video to TMZ? I think it's a fair argument to bring this up, truly, because it's also a way that he's going after her. And we've switched into her attorney now arguing why she should have a restraining order, keeping him away from her, not just her away from him.
Last year, my client, she was announced as ABC's Bachelorette. Filming took place in the fall. The season was supposed to have debuted on March 22nd. However, on March 19th, the same day he filed his amended request for a protective
And
order,
Ever's
a
birthday.
news outlet published the video of this incident. Before this release, it had not been out in the public. So this was released 3 days before the big debut and coincided again with other actions he was taking with the protective order, as well as coordination, additional reports to law enforcement. In addition to the timing, which is extremely coincidental, the declaration of Jesse Draper, which you alluded to, Your Honor, indicates that in the days leading up to the March leak, Ms. Draper entered the basement of her home, that's Ms. Draper's home, to find Dakota speaking with Ms. Draper's husband, Jordan, as well as Dakota's roommate. She noticed that he was very animated, that Dakota was very animated. He was venting his frustrations with cops not doing anything, and told her he was going to take matters into his own hands to embarrass Taylor. He specifically told Ms. Draper
Oh, shit.
that he planned on leaking embarrassing videos of Taylor to the press, starting with the Barstool video. He specifically named TMZ as the outlet, and a few days later, that exact video
Oh,
was
shit.
released by TMZ. He's not just trying to come after her for custody. He's not just trying to seek a protective order. He wants to literally destroy her. He wants to subject her and her family to a new round of torment. Yes, there are career implications to it. There's mass embarrassment associated with that. But ultimately, our big problem with that, my client's big objection to his conduct was, this additional harm and embarrassment and shame that he inflicted on my client as well as her children. This was a step too far, and we think shows his true nature.
So the reason it's rebuttal and response is because Dakota's lawyer made their argument for why Dakota should be granted a restraining order. And then Taylor Frankie Paul's attorney made his argument that she should be granted a restraining order against Dakota, but that she doesn't need to be restrained from contact with him. And the argument from her is essentially, I'm not the problem. He won't leave me alone. And then the other side of that argument is, I'm not the problem. She won't leave me alone. And so I think it's a hard thing to argue, because at the end of the day, you just restrain them both from each other and go just move forward. So now, because we have heard from Taylor Frankie Paul's attorney, now we are going to hear from Dakota's attorney again on kind of rebuttal response on the other side of that.
So I see 4 allegations in her protective order against my client. I'll go through them line by line, Your Honor.
Oh,
The
that's
first
so
one, you've
organized.
seen
We
our
appreciate it.
declaration opposition with its exhibits. I'll try not to burden the court by reading it directly. Regarding the May 27th, 2025 assault, as you can see from our declaration, my client reports it was actually stricken before he turned the camera on. Once the camera's on, you can see her acting extremely violent against him. When he was able to turn the camera off, remember, he was holding his son. She was grabbing him. You see the information that we have here. we suspect her injuries were occurred from her.
I'm more interested in his explanation for her injuries.
So the wrist is likely because he had only one arm as holding the kid to try to get her arm off because he was trying to get out. She tripped. And I think the tripping and the kicking on the floor is likely where the bruises to her legs happened. He does not believe he ever kicked her at that point in time. And I do have some interesting bits about that.
He doesn't believe?
Well, yeah, he was.
I was going to say the same thing, Your Honor. He doesn't believe that he kicked her?
Well, yeah, he was being assaulted. So it's a little hard to figure out exactly where things were, but he does not, he will definitely, if I called him to testify, I would testify he did not intentionally kick her in any way. But when you have someone falling on top of you and you're trying to get away and you're trying to hold your son, you know, legs can kick out, you can fall backwards. He was trying to hold his balance. He stepped on a toy.
Did the video show him falling down?
No, the video stopped before that. That's the unfortunate.
He was able to turn it off while he's falling?
No. He did not fall. He started to fall as he fell on the toy, tripped on the toy. And that's when he realized, okay, I've got to get my hand. So he turned it off. Now let's head over to the February 22nd incident. You've seen our response, Your Honor. We see text messages. She indicates in her protective order that he was harassing her and trying to come over and trying to hook up. The text messages that I submitted, extremely clear. She invited him, and she invited him for the sole purpose of intimacy. And I think that's extremely why we keep seeing this cycle happening. And he did go over.
I just have to back up. I mean, they entered into this stipulation for 50-50 custody in June of 25.
I'm aware.
After this all happened.
Yes, I'm aware.
Okay.
And that's part of the problem, Your Honor, and I'll get to custody in a second. But that's why I
Yeah.
mentioned those issues, is that this is a man who I would expect a lot of male domestic violence victims is he's trying to make things work. He's trying for the sake of his kid. And he's still enticed. He still has this spark of romantic relationship that occurs, but then it's a cycle. Then it breaks down. Then there's an assault. Then there's a, kind of a, oh, I'm sorry, here we go. And you can see, like, for example, perfect case scenario on the 22nd incident when we're talking about the broken necklace. You actually submitted the text where she said, I bought you another
She has a lot to say to her lawyer about that.
necklace. Well, I can quote it, but I bought you another necklace for the 1,000th time.
All right. Okay.
1,000th time. That's a pretty good statement.
But also the commissioner's saying if Dakota is relying on the incidents in May 2025 to say that he is afraid and needs a protective order, how are they able to then come to a custody agreement? So the commissioner is looking at what happened in February. And I think the commissioner is almost anticipating the attorney for Dakota to say the February incident was the final incident. That is the final incident. And because of this incident in February, this is where he realized that this is never going to change. And he went to law enforcement and he filed for the protective order, and he is taking an affirmative step towards breaking this cycle. And I'm surprised that Dakota's attorney's not arguing that, because he is the first one that went to the court to ask for the restraining order, and he initiated those things.
He gives a pretty good incident. I mean, you can see on the 22nd, that was the thing. She jumped on top, strangled him, pulled his necklace, broke it off. We have the text messages that support that. And then we have again, that one I do want to mention. He did call 911 that night. That was the first inkling, because he realized, he looked over at his son, saw his son terrified and crying, and went, I can't do this anymore.
Oh, the argument. Emily, keep reading.
I've got to take it. I can take it. My kid can't.
This is, are we
February
leading into
22nd.
26?
There's that argument.
2026.
One where we don't have any.
I had thought that a third party called 911. I did not know that Dakota called 911.
He regrettably, she said, please don't. And so he makes something up and says, oh, we're wondering if the kid's sick, because the kid was sick earlier that day. So it's not a lie, but he chickened out. He didn't tell police I've been assaulted. He didn't want to face that wrath. And so he left. Section 78B 7108, mutual protective orders. I don't get to refer to this statute very often. When two parties have filed protective orders, the court may not grant a mutual order or a mutual civil protective order to opposing parties unless each one's filed their own. That's happened. And there's a showing that, there's basis for it. But it becomes the party's burden, including Ms. Paul's burden, to demonstrate that the abuse or domestic violence she's claiming did not occur in self-defense.
Interesting.
We're saying it's self-defense, Your Honor. He
Okay.
had to stop the attack. He did push her off. It's possible she got a bruise to her head. He didn't see anything. He didn't see a bloody nose. She said her bloody nose. He went back the next day. There's no bloody nose. She's not saying anything. It's in the text messages. We think the credibility there is, it's very easy for her to, if she's attacking him, to harm herself or to get hurt by hitting him. It's very easy for her to push. He is stronger, and she gets thrown into the door as he's trying not to crash the car, where the kids are at home alone. So he goes there, he pulls off, she gets out, and here's what's interesting. Okay, and this is why I struggle with the credibility of Ms. Paul's statements. That right after that happened, she proceeded to call him 11 times, and we submitted those phone logs. You can see them. 11
And he was
times.
texting her.
And in the very first one of the calls, he would say, because it's not recorded, it's called, she actually says that phrase that she then used later to say he's this harasser, so you don't want to fuck. That's what she said in the first call after this whole thing happened. That's what she says. In which he was like, what are you talking about? He
boy.
said no. He gets 10 more calls from her. It's in the phone logs. We submitted them. Saying that they should return. She then says she has a bloody nose. He's concerned, so he goes there because she says, again, using the kids, I need to go to the ER, someone has to watch the kids. He goes, tries to get in, knock on the door. She won't. Sees through the window. She's there. There's no bloody nose. And so he leaves. And you see the text messages that we provided. You can hate me. It's valid, she says. He says, finally, the intimate relationship's over. And we submitted those text messages.
Okay.
I think it's really important that he's finally had the courage to break this cycle, Your Honor. But I need to respond to a couple other things as well. So February, it sounds bad. When I first heard about this tattoo thing, I went, geez, Dakota, what are you doing tattooing something on the inner of your lip? And he gave me an explanation I wasn't prepared for. Makes a lot of sense. It was a filmed segment of the TV show, Your Honor.
Not one we saw.
All the dads decided to go down to the tattoo parlor as part of the Secret Lives TV show. It was filmed.
This was Jordan's idea, wasn't it? This was Jordan's idea, wasn't it? This was Jordan's idea, wasn't it?
They all get tattoos and they all think, oh, it'd be so funny if you put Taylor's initials in your inner lip. And it's something else I didn't know until I looked into this. Inner lip tattoos, the reason why people do that is they fade. They are not permanent. They go away.
I have no idea whether that's accurate.
That is accurate, actually.
I will
Expert
proffer my client's
testimony
testimony.
to
In fact, if you want,
One way or the other.
it's not really there anymore.
It's actually true. That's
so
true. And I bet this was
that's
Jordan's
why.
idea.
So it's not something that shows or permanently affects the bodies. My client would proffer his testimony right now that very night of those text messages that you saw of her allegedly being freaked out about it and thought it was possessive, they were intimate that very night. We believe her protective order, she filed minutes before the first hearing on April 7th, is not designed to protect her son, it's designed to protect her image. And her image has a lot of value. And so that's our argument in terms of credibility.
My client, she is taking accountability for her role in that. She's owning not just her participation in that, but the actual misconduct that related to it. We've gone through some of the allegations in the protective order, Mr. Mortensen's request for a protective order, and she's provided some context and some accountability for that. Mr. Mortensen does not own anything. He's not owning up to anything in this case. His strategy is extremely simple.
Do you agree with Taylor's lawyer in this? Do you agree with his argument that Dakota, in his argument, is taking no accountability or responsibility, and that she, in her arguments, has taken some? I'm just curious where you guys are at on that.
Deny everything. His only crime, as he tells it, is to give in to her advances. No mistreatment by him, no abuse, no violence of any kind. The February 23rd, 2026 incident. Need to evaluate this and scrutinize this one as well. What the evidence actually shows, despite what he has alleged regarding this, what the evidence demonstrated to investigators, and which we think is more credible, is, again, he assaulted her, violently grabbing her by the shoulder and throwing her into the dashboard.
Okay.
I looked through his declaration from 2 days ago. I don't even think he acknowledges that his force sent her into the dashboard, but he acknowledges that in his written statement to police.
All right.
So he's having a hard time kind of keeping his story straight and providing some context for her injuries. So we believe that these instances, among other things, among his possessive behavior, which we've outlined with some examples in our exhibits. His vindictiveness in terms of trying to, again, go one step ahead of things and ruin her life with the leak. We think that this will be important to have a protective order entered for her. She'll certainly benefit from it, and she's met the grounds for doing so. Do have a couple comments on his protective order as well, Your Honor.
I think they will both benefit from a protective order. That's where I'm at with it.
Again, she's trying to take accountability, and she has done so in this case related to the bar stool, and
Can I
certainly.
ask a question about that too?
Sure.
Didn't she make those same arguments at the time of her criminal sentencing?
Yeah,
Oh, boy.
I was not involved in that, so I don't know exactly which statements.
I bet the court has the transcripts.
All right. Okay. All right.
But we believe the court has discretion, certainly, to enter a protective order in Dakota's favor, but it's not mandatory in this particular case. He has shown zero fear of my client whatsoever, which is an element. It's not a silver bullet. I don't know that there is a silver bullet, but it is a relevant element to consider here. You can see it in his expressions and how he communicates to her during even their most heated exchanges. He eggs her on, laughs in her face, insults her relentlessly. You can see this lack of fear in how he pursues her over and over again, love bombing her, manipulating her. Examples of these possessive overtures are included as exhibits B and K in what we've submitted to the court.
Mhm.
We can see this in how he's working overtime to completely destroy her. He is obsessed with this woman. He's not in fear of her. Those are different issues. If he was in fear, if he's truly been in fear, trapped in this violent relationship for over 3 years, if he truly considered himself a victim who needed protection, why would he instead just sit behind a camera and just stash embarrassing, difficult moments in their relationship? It's not really in line with what we'd expect, how we would expect a victim to act. And so we are asking
That's
for
not going to
entry of
fly
the
with this
protective order in
judge,
her favor
counsel.
and denial of Dakota's protective order, Your Honor.
Okay.
We're going to hear from the guardian ad litem regarding parent time. Remember, parent time is something that, because Dakota filed first, was modified from their current child custody agreement. So they are trying to talk about when parent time is going to shift and if it will shift. Because at one point, parent time had been 50-50. At one point, it had been 70-30 with her having 70% of the parent time. And then when Dakota filed the protective order, he requested 100% parent time and got it. And then they modified it on the April 7th hearing. And when they modified the parent time, she now only has supervised parent time. So they are now having a discussion about parent time. We're going to hear from the guardian ad litem, who is looking out for the child's interest, not the father, not the mother. What keeps the child the safest?
Frankly, since we were here last time, my opinion and recommendation hasn't changed, and it's still based on the same argument.
You can see all the attorneys in the courtroom turned toward the seat where the guardian ad litem is.
That I made previously. I've reviewed all of the new information. I tend to agree with the police report that as you read through everything and look at the evidence, it's difficult to find credibility with these February incidents from either party, frankly. Domestic violence related child abuse can be a little bit interesting in that sometimes you might have a child in the room next door, but the child's not in like direct harm. In this situation,
The child was in direct harm.
The child was sitting
Yeah.
right there. The chair hit the child
And
in
was
the head.
hit.
And
Yeah.
that didn't stop her. It didn't stop her actions. Again, she pled to the charge. She did the DV assessment as part of her probation. She's complied with probation. She completed, from what I can tell from the probation report, everything that she should have, and she should have learned from that. And then we go back to this May incident.
Right.
And I understand, and I said this last time, there's a beginning that's not filmed and there's an ending that's not filmed. But what is filmed is Mr. Mortensen holding his son and Miss Paul coming at him and pushing him and pushing him. And I don't think it's the trip incident that has been discussed, because it sounds like that happened after the camera was off. But you can see Mr. Mortensen, you can see the camera go like this, and then it kind of ends. It's clear to me, I mean, that was, again, putting my client at risk of physical harm. I am really concerned about, like I said last time, Ms. Paul's ability to control her behaviors in these situations.
Well, I mean, this is the question I have for you,
Yeah.
which is I don't see really that there's any other, let's say no criminal matters I could find regarding Dakota. And the only criminal matters that were found had to do with the interactions that they had with each other. And even in the videos too, as well, the injuries, these are all relative to interactions the two of them are having with each other. What's the risk in terms of to the children if I'm keeping them both away from each other?
I think the risk is
That's a
that
fair
when you have
question.
someone who perpetrates domestic violence or is involved in domestic violence, and there's no sort of learning to control the behavior, I think the risk is that there can be future relationships with other people, that those relationships can lead to domestic violence again. I think that there can be additional fights that happen with other people, but I agree, there's no criminal history there. It's just those two situations were extraordinarily concerning to me because there wasn't that sort of wake-up call when the child was put in harm's way. And again, it's my concern that there's a lack of control there. My thought is that the family is working with the division. They're doing services with the division.
What happened with the case closure on the DCFS investigation?
Supported mom for DVRCA and supported dad for failure to protect.
Oh, they both were supported.
Correct. One for failure to protect, the other one for DVRCA.
They're talking about the Division of Children and Family Services providing support or services to both parents. And you saw the commissioner respond to that. They were providing services to both. Yes, as to Dakota, failure to protect, meaning failure to remove the child from the anger and the situation with Taylor Frankie Paul, and Taylor Frankie Paul for DV in the presence of a child. So as to both of them.
What I would like to do, and I understand that the court has the primary custody case also, and so, you know, maybe this isn't the best idea in the world, but what I would like to do is set a review date and come back in about 60 days and see what the progress is on the DCFS cases.
Well, what I think I hear you saying is you're more concerned about her conduct than his, though. I mean, any concern about what you've heard with respect to his
said.
conduct?
I agree. That's what
I mean, absent her behavior, I mean, there's certainly.
The guardian ad litem is more concerned about her behavior because her behavior does not cease when the child is around.
Under certain circumstances, I might consider supervising him as well.
And I understand that too. My biggest concern, well, I'm not going to sit here and say I don't have concerns with his conduct. I mean, I've listened to the audio, I've watched the video. I don't understand from his position how when he's being attacked, rather than booking it out of there, which would probably end things, he pulls out a camera and films it.
Well, I had those same thoughts.
Yeah, that is a concern for me. But his actions, as I see it, he's not throwing chairs that are potentially hitting my client.
Right.
He's
a difference.
holding my client and backing up when he's getting pushed.
There's a difference. I have some thoughts about that too, about the nature of each of their behavior.
And I do take issue with the continually saying that Dakota isn't taking, or Mr. Mortensen isn't taking responsibility.
Counsel.
That's the responsibility he's taking. He believes he needs to break this cycle of continuing to essentially fail to protect by not withholding, not saying, no, we're not going to come back. I'm not going to take your text messages again. I'm not going to expose my child.
He could have done that way.
He could have.
But he chose instead to file for a protective order.
That was his method of saying, I'm done and we're over and we're going to separate. And I think
Right.
that's a good way to do it. And we shouldn't blame people for filing protective orders to assist them with that.
Well, your argument though was that hers was in a sense retaliatory, but
That
think
was
there's
his
a
some
argument.
component to
evidence
it.
there that, in terms of her bruising
And,
as
and-
well, passage of time. In one sense, you're arguing we shouldn't be dismissing his request due to the passage of time, but you were suggesting maybe I should with respect to her.
No, hers, the most recent thing we're saying, it's just not credible. It doesn't rise to the level of
All right.
domestic violence or abuse, Your Honor, what she is saying he's done to her. He's trying to defend himself and leave. We have ample evidence presented that she has committed domestic violence and abused him. So we only need one protective order to keep this running. And his is to protect, we only need one to separate the two and do this. If he violates the terms of the protective order, I know it's not a criminal violation, then she can say, well, you're back here again. And trust me, the division won't like that either. Both common sense and expert opinion indicate that a parent's act of domestic violence can have adverse effects on a child, even if the child is not the direct object of such violence, and even if the
Right.
child does not directly witness the violence. You've heard conflicting testimony. I know you have to make a call, Your Honor, in terms of credibility, but the one thing that's run throughout this entire case of all the evidence you've seen is we have multiple incidences of domestic violence being perpetrated by Ms. Paul against my client. We don't need her protective order. We don't want to put them on kind of the equal footing here. We need to call out who's the abuser and who's the one that's failing to protect from the abuser
And that's
in
his
the past,
argument.
and he's trying to protect today.
There certainly is a risk that if he's not ordered to stay away from my client and not communicate with her, if there is not a protective order in place, there's certainly a risk that he's going to fall back to his old ways. So that is, among other reasons, why a protective order should enter.
All right.
On custody, I'm happy to address that now if you'd like, Your Honor. On custody, you asked.
I mean, you're here to
what's the
talk about
vision for this
custody.
case from here.
That's the point.
Depending on how we handle it, we could either get some resolution, some movement, and a restoration of custody, or we could just go into, an infinite review hearing death spiral, which I don't know if anyone's particularly interested in. It has been very
The turn of
difficult for my
phrase,
client to
counsel.
come up with words to describe how she's been affected by being cut off from ever over the last 6 weeks. And for the first 3 weeks, it was completely cut off. And then the court somewhat relaxed it beginning on April 7th. As far as the custody case, the court already understands and has pointed out the strangeness of the fact that Dakota agreed to give my client custody only in August of last year. And I do have to correct the record. It is not a 50-50 agreement. It is approximately 70-30 agreement.
That's right. That's right.
In my
Yeah,
client's
yeah,
favor.
yeah.
So they followed
thought
this
it
from the date it was
was
signed. There were some exceptions for travel and work schedules.
70-30.
He never asked for supervision in the custody matter. By signing the agreement, it's obviously important for a variety of reasons. He gave custody of this child to Taylor only a few months ago. And I think that implies that he understands that she has skills, parental skills, parental fitness, and a very important bond with Ever. And he has an important bond. Ever has an important bond with Taylor, sufficient to justify giving her custody of this young child. Also, she already has made, and they have already made some adjustments that are helping the situation. She's trying to take accountability and move on. She has been working.
In what way?
She's been working with a therapist. She'll continue to do so.
I don't have anything from the therapist yet.
That's
right?
correct.
Okay.
I'll just close with saying these visits, the back and forth, the abrupt end to these short exchanges with Ever and Taylor are excruciating for both Taylor, Ever, and these two other kiddos.
I just don't have an independent report. I think that's your client reporting to you, right?
As well as the supervisors, but also I think it's a pretty reasonable assumption to make that a 2-year-old child seeing his custodial parent after 3 weeks absence is going through a lot of confusion right now.
Different kids are different. Some are more resilient, some are more adaptive, but yeah, I understand what you're saying. Both counsel referred to it. This has been a very toxic relationship. It's beyond the pale in a lot of ways, the toxicity here. And I've had some thoughts about this, about what's this dynamic that we're seeing here. There seems to be a continuing attraction that they have for each other, whether it's physical, whether it's the thrill of the two of them, being a part of making themselves celebrities. There seems to be this attraction that they continue to have for each other. Each of them have been texting each other, wanting to get together for physical relationship,
all the texts.
to continue on to the physical relationship. In some cases,
He has had to read all the texts.
she's invited him over. He said okay. In other cases, he wants to come over, and she lets him in. And the problem is that the two of them can't be together in the same place at the same time for very long before it starts to turn violent. And that's part of the problem. When we talk about cycles, this is part of your legacy. This is the legacy of violence being passed on from perhaps generation to generation. I don't know. I'm not familiar with your childhood.
Wow.
But it's certainly concerning all the way around.
Ooh.
Meanwhile, I have to make some decisions about, because you couldn't come to agreement as between yourselves, I have to make some decisions about not only entry of orders, but then on top of that, if not here, then in the domestic case as well, about what your parent time arrangement is going to look like, at least for the short term at this moment. I think there's some merit to both of their arguments about their bases for protective orders. I certainly think it's an easier call with respect to Dakota's request for a protective
Wow.
order. The video evidence is really
Right.
overwhelming. And in terms of the elements that go into that give rise to the basis for the entry of a protective order. At the same time, I think there's also evidence, and I'm finding, at least with respect to the May of 2025 incident, that while the bruising, the injuries that Taylor suffered, it's certainly possible that some of these injuries could have been the product of self-defense, but I'm not finding that it's probable. I'm finding that there's been violence that's occurred both ways between these parties. And I do think she's met her burden as well. And I do think it's important that there be mutual orders as well.
Yep.
They need to stay away from each other.
Agreed, Your Honor. Agreed. I agree.
I'm wary when it comes to the supervision aspect of it, although I'm not going to make a decision on that right now, that if I'm continuing to supervise Taylor's parent time, I'm wary that Dakota may actually try to use that as a way to manipulate and control her. I'm hoping that you're not people who just thrive on the drama and the conflict. You've got to put your child first.
I have the same concerns, Your Honor.
The child from this conflict. So my recommendation is going to be mutual protective orders.
Good. That's the right
I want
call.
there to be 100-foot stay away for each of their orders. I'm going to leave the current order in place. I need to think a little bit more about this lifting of supervision. I have mixed feelings about it. On the one hand, I do have some concerns that if Taylor is in a stressful situation, she has not demonstrated an ability to control her emotions. But as I also said, that seems to have only happened when she's been in the same vicinity with Dakota. And like I said, I'm wary about the supervision aspect. The court, I guess I should say this, the court would have the regardless of what either party may want, the court would have the ability to lift the supervision at any time. I do think there may be some benefit in waiting to see what's coming out of the assessments that have been ordered from the safety plan. I think there's some benefit there, but I'm also contemplating additional time as well.
At the end of the day, the court ordered mutual protective orders against each party. That is also going to extend to things like texting, calling, FaceTiming, no communication. And the only communication that they will be allowed through a third party is not third party, baby, I love you text message. Third party, we are exchanging the child at this location. The child is sick. This is what we are doing. We are taking the child to the doctor. Conversations regarding mutual parenting. And the court issued those mutual stay away orders, protective orders, for 3 years. They will automatically expire. Could the parties go back to court and ask for those to be removed down the road? Yes, they could. But what is the court hoping to accomplish? Well, the court actually had quite a lot to say to these parties about the nature of their relationship and did not think much of it. Said that he found that Taylor's behavior was reactive, that Dakota's behavior was calculated, that these parties need to stay away from each other, and basically sat there and said the two of you need to do better for your child, because right now the legacy that you are leaving is a legacy of domestic violence and abuse. And the court looked at all of them and said, or both of them and said, the goal is that you don't need court intervention down the road to parent your child, but you are going to be connected together through your child for the rest of your lives. Essentially, so get it together. So what does that mean for the future of Secret Lives of Mormon Wives? I believe I saw reports that Taylor Frankie Paul was stepping away from filming, which I guess means if she's not filming that Dakota could film, but they can't film together, and they can't have Dakota saying something to Jordan and then Jordan saying something to Taylor or something like that. You cannot have them also talking through third parties. That includes, you couldn't have one of them sitting down and filming and then production saying to them, hey, so-and-so was saying this. How do you respond to that? I don't think they should be filming together. I don't think they should be filming at all. I think both of them need to address what's going on with them, and they need to do so away from the cameras, which I understand is a difficult thing to ask when that is where your job is. However, they're going to need to figure it out. And the court was very clear on that. You're going to need to figure it out. So, 3 years of mutual protective orders. The court is going to figure out parenting time, but is contemplating removing the supervised parenting time. It seems to me, based on the court's statements, and I would love to know what your perception of this was, but it seems to me that the court's concern was what happens when the two of them are in space together, talking to each other in the same location and interacting with each other. That seems to be the biggest concern. I was surprised to hear how much the court gave credence to Jesse, who is also part of the cast of Secret Lives of Mormon Wives, Jesse Draper's affidavit to the court that was filed yesterday. And I was also surprised to hear that Taylor's attorney brought up whether Dakota got Taylor's initials tattooed into his lip, and it came up in court. And then Dakota's lawyer was like, so, Your Honor, funny story. All the dads went out to a tattoo parlor together and were filming, and they thought it would be, gee shucks, real funny if Dakota filmed getting Taylor's initials tattooed on the inside of his lip. So, Your Honor, really, it's not creepy behavior, and it's not like stalking behavior. It's just like dad talk. The lawyer didn't say dad talk. I inserted that myself. So it was an argument I have not seen before in court. So we'll see if that makes it to air in whenever season 5 of Secret Lives makes it to air, if it does. But I think the court clocked that these two shouldn't be interacting with each other. And I agree with the court's assessment of all of that. And the court has seen more of the videos taken and of the interactions between the two of them, and came to the conclusion that they need to not be together. They need to stay away from each other. But also, the court does not want to put either party in a position to leverage, well, I have a protective order against you and you don't have one against me. And the court seemed very conscientious of not creating an uneven playing field or an area for one to manipulate the other, and was concerned about that and noted that concern. So where do we go from here? Well, when the parenting order is updated, I'll keep you updated either in the podcast or in shorter form content. When they do a check-in on this, I don't know if we will go to court and check in on that. I was curious to see how the court would navigate the mutual protective orders, and the court navigated it with stay away from each other. So what does that mean for The Bachelorette? I don't know. Does that mean The Bachelorette is going to ever air on Hulu? I don't know. Will they just cut everything Taylor and Dakota out of season 5? Maybe. And at what point does production start to look at the fact that these parties should not have been filming together at all beyond that first incident? And at what point, when people's money and the way they make money is directly connected to conflict with each other, at what point does that reach a breaking point? And I think we're definitely seeing it here, but we're seeing lawsuits, as I talked about the last time we talked about this. We're seeing lawsuits elsewhere, not with regard to Hulu, but with regard to Bravo, about where those boundaries are. And I think this case and others are going to start to redefine where those boundaries are on reality TV. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.